So I'll get us started. So a very warm welcome, everyone, on behalf of Connected Minds and CAIS. This event, we're joining forces together to host an exciting speaker. And I have to say, when I received the email from Dov Greenbaum, Professor Greenbaum, that he was going to be in town, I was very excited, and I jumped at the chance to bring him here because really his work is so on point with everything that we're doing. So my name is Pina D'Agostino, and for those of you who don't know, I'm now the Scientific Director of Connected Minds and the co-director, along with James Elder, of the Center for AI and Society. And both are fairly new at York University. So Connected Minds, for those of you not familiar, is really an exciting project where we are funded by the CFREF, Canada First Research Excellence Fund. It's a historic grant for York University in collaboration with Queen's University, where we're really tackling the complex questions of today with the increasing intermingling between technologies and different machines and humans. We call it a techno-social collective, and trying to get ahead of the problems and advance socially responsible tech. And so what you'll hear today is a lot on that. And of course then the Center for AI and Society bringing together diverse disciplines and looking at technology with society hand in hand is what we try and do. Because again, Connected Minds and CAIS is really about bringing together diverse disciplines and doing interdisciplinary work. And there's no one really that I think does it best than here at York University. And it's not lost on me that we're here at Osgoode Hall Law School, which is a powerhouse of law, policy, regulation, and all things that we need to move forward in a democratic society based very much on the rule of law, which we very much believe in here in Canada. So in many ways, what we're doing today is welcoming back one of our very own, not only on the work side front, but also on the Canada front. So Professor Dov Greenbaum is actually born and raised in Hamilton, very close to here, so welcome back. And I first got to meet Professor Greenbaum when, I think it was back in 2017, when we started the Bracing for Impact series here. Again, that was also getting ahead of our times, really looking at the technology and seeing with the advent of AI, you know, how we should work together as a society. And Dov was top of mind to bring forward as an expert in the area and to really weigh in on these important issues. So that was back then, yeah. And here you are still forging forward with all of your exciting work. We were talking with Caitlin all on the neuro stuff, so much more collaboration ahead. Professor Greenbaum is a lecturer in biomedical informatics and data science at Yale University. In addition, he's the founder and director of the Zvi Meitar Institute for Legal Implications of Emerging Technologies. So again, all of what I've been saying, he's living it and through his work. Dov teaches at the intersection of law and tech at the Harry Rasner Law School at Reichman University, and we have many dear friends there. He also teaches genetics and bioethics at the Dina Rekanich School of Medicine. Dov has degrees and postdocs from Yale, Berkeley, Stanford, and ETH Zurich. He is a licensed to practice law in California and before the US Patent and Trademark Office, and he's a certified privacy professional with the IAPP. So we definitely are in the room with greatness and talent, and no better person to lead us through these important discussions than Dov, who'll be, his title is quite provocative: Guardians of Genomic and Biometric Data, Governing Innovation, Privacy, and Equity in a Fragmented World. So with that, very warm welcome to you, Dov, and look forward to hearing you talk for about half hour or so, and then we...
Cut me off when you need to.
All right, and then we'll open it up for questions. So a big round of applause.
Actually, another area that it. So we got some papers in an area that we sort of coined called cyber neurosecurity. So there's another area it's an emerging area called cyber biosecurity. It's very much focused on the intersection of cyber, AI, biotech, and privacy aspects. And there's a much narrower sort of world of cyber neurosecurity, which is also really sort of fun and interesting. So we should talk about that as well. Okay. So, that's 23 and you. All right. So someone should stop me. 2 caveats. Number 1, I tend to speak quickly, so slow me down. And number 2, I tend to speak quickly, so slow me down. Important. So I want to talk about an area that's really near and dear to me. I actually started off as a geneticist, and I got into the area of law because I was threatened with lawsuits for doing my science. And I was young and naive, and I believed that we should have access to basic science information as a rule, as a policy. I was what we call bioinformaticians. So I was doing bioinformatics, which is this intersection between computer science, genetics, statistics, whatever. And one of my problems was that we don't generate our own data, but we suck data out from all these other places, and some commercial places weren't so happy that we were doing that. And so that got me really interested into the area of law. I was at Yale at the time, and I went to, as opposed to a very practical school like Osgood, Yale Law is very, well, now I'm being recorded, but okay. Yale Law is a very not practical school in terms of what they offer, but I took all their courses in intellectual property, which wasn't that many. And I actually wrote a paper that I published in some law journal as a geneticist in the area of sort of access to information and why there should be a general access to information. And today I'll talk about why maybe there shouldn't. So I sort of switched gears. I sort of evolved, I guess, after being a litigator for some time and trying to protect people's data. So I think it's important to protect data. I'm not sure how to go about doing it, and I'll explain why. So the impetus for this sort of talk is 23andMe. I don't know if I'm allowed to ask this in Canada. I don't know if there's probably laws against it. But has anyone done 23andMe? Anyone had their genome sequenced? No one's done it? Okay. So 23andMe are you familiar with the company?
Yeah.
Mm-hmm.
Okay, so it's a really interesting, cool company, and they're very forthright in that they're collecting big data on genetic information. And I'll skip ahead to understand what big data is. Essentially, we talk about it a lot, but I'll just say that effectively big data is defined, at least by IBM, as a lot of data. So they call it the 5 V's. Volume, velocity, variety, veracity, and value. So it's a lot of data that comes really quickly, lots of different data types, hard to sort of trust, but a lot of value. And typically when we think of big data, we think about collecting big data, we think of these evil guys, FANG, which doesn't really work anymore because Google is now Apple or Alphabet, and Facebook is now Meta, so whatever they call themselves, and we throw in Alibaba into the mix. So, but essentially, right, this has long been sort of the mantra, particularly from people like Jonathan Zittrain, formerly of Oxford, now at Harvard, essentially saying that, if something online is free, you are the product, not the customer. And for the most part, we've agreed to live like that. We want free social media, we want free access to everything, we want free email, we want free search, and we're willing to give up our very personal data to get that. But what we haven't really experienced, and clearly no one here has done it because no one's sort of sequenced themselves, and in full disclosure, I haven't either. But what we haven't really talked about is an even more personal data. So when we think about your social insurance, I don't even know my social insurance number, I just need it when I have to go to the bank. But you think about your social insurance number, your social security number, your passport number, your driver's license number, all these numbers are effectively very easy to change. With the right people, you can go in and you can have your numbers change, you can have your identification information change. Even your fingerprints you can burn off and stuff like that, but the one piece of really informative piece of information that you can never change, at least not yet, is your genome, your genetic information. And so this is I guess, a very personal piece of information, and we would think that we want to protect the privacy of it in a more robust fashion than we do for other areas of information. I should note that I'm not a big fan of all the privacy regimes out there. I think they're kind of silly, GDPR included, because in privacy regimes what they do is they distinguish for some reason between personal data and sensitive data and different types of data levels. And for me, in a world of big data, it makes no sense. Why? Because there have been numerous sort of cases. Target is the one that comes to mind. I'm sure, well, we no longer have Target here because they left, they ran out of the country. But there was a famous case, it was the front page of the New York Times a long time ago, where a father of a 15-year-old girl received a distressing letter from Target essentially saying, here are coupons for your pregnant daughter. And the man was clearly incensed, and rightfully so. Who are you, Target, to tell me that my 15-year-old daughter is pregnant? How could you say such a thing? And Target said, well, what can we do? Your daughter shops like a first trimester woman would shop, and so we just assumed that she was pregnant. First trimester women, they buy pickles and ice cream and shea butter and whatever else, and so your daughter must be pregnant. And it turns out she was. And why? Because even from very publicly available information, even very non-personal information, we can really easily deduce very personal information. So that's just my dig on all sort of these frameworks that I think are silly in that they make this distinction, because it's not a real distinction anymore, and it hasn't been for a very long time. But genetic information, I think, deserves a special place in our privacy rules, mostly because, again, there's this concept of genetic exceptionalism. It's this idea that genetic information is somehow more special. We see this in the criminal law area, where if you get, and anyone who watches CSI, all the CSIs or whatever, all the Law and Orders. Well, I noticed there's a Law and Order Toronto now, right? Is that a new show? So when they talk about there's a genetic match, we automatically think, oh, the guy must be guilty. To the extent there's already this CSI bias that they see already in the courtrooms, where it's already leaked into sort of the jury system. Nevertheless, genetic information is a more type of personal data for a whole bunch of reasons, a very different set of data than all other personal data. And unfortunately, I think that it may be in trouble, and I'll explain why. So, 23andMe. Anyone been following the saga of 23andMe? Yeah? It's a little. I hope no one here is invested in 23, but it may be a good time to invest because they've hit rock bottom. How so? So this is what's really going on right now in 23andMe, is that Anne Wojcicki, who is the founder and former wife of Sergey Brin, who founded Google, she is the CEO and founder of 23andMe. It was founded around 2007, and at this point, she can't do anything with the company. The company is really distressed, and there's a lot of trouble with the world of 23andMe. So let me step back and give you a quick history of why 23andMe exists, and I'll take you guys back to 2000. Anyone remember the good old days of 2000? Y2K. This is the front page of the New York Times. Genetic code of human life was cracked by scientists. There were two groups. There was a public group that was headed by the head of the NIH, Francis Collins, and a private group headed by Craig Venter. And together they quote-unquote sequence the human genome. Now, of course, the New York Times is lying to you. They did not sequence the human genome. The human genome wasn't sequenced for another 10 years or so. Parts of the human genome were sequenced, but nevertheless, it was a big deal. Bill Clinton was ecstatic about this, right? There was a whole sort of press release, a press conference in the White House with, that's Craig Venter over there, and that's Francis Collins over here, front page of Time magazine, which I don't think exists anymore in print. Science and Nature, everyone was talking about this. This was the biggest deal. And why was this the biggest deal? Why was everyone so ecstatic about sequencing the human genome? And, okay, yeah, it's great and everything like that. It cost billions of dollars to do it. But one of the reasons was related to this paper that, that Francis Collins, again, the head of the public group that did it, wrote soon afterwards in the New England Journal of Medicine, and he's talking about how this is going to change the process that we make drugs. So here in Canada, we're very lucky and very fortunate to have cheap drugs, but over the border, drugs are very expensive. And why are drugs effectively so expensive? And why is the American population subsidizing it for the rest of the world? It's because drugs cost a lot of money. Drugs cost a lot of money to develop, not individually, but because of all the failures. So there's this concept of the drug pipeline, and you'll get thousands of drugs that start off for a particular disease, and at the end of the very long pipeline, you will end up, hopefully, with one drug that actually works. And of course, that drug doesn't always work, and there's instances and failures and everything like that. But we are paying for the failures of all those 5,000 drugs through all the clinical trials, through all the FDA oversight along the way, and that one final drug sort of has to make up for all that lost profit. And science has always tried to figure out how to make a better drug, how to make a faster drug, so AI now is sort of the key. But before, it was the sequencing of the human genome, maybe that will help us, and before that, it was combinatorial chemistry that maybe would help us. There's a whole pathway that we've been thinking about, and we thought, at least in the early 2000s, that DNA and the human genome was going to light up the way, and we were going to somehow figure out how to make cheaper, faster, better drugs. Now, partially, one of the problems is that we need genetic information. And the problem with getting genetic information, at least at the turn of the century, was genetic information cost billions of dollars to get. Sequencing isn't what it is today. It was expensive, it was slow, and part of why sequencing became cheaper was there were a bunch of companies who at the turn of the century, or a little later than that, decided we can monetize the human genome, we can monetize this interest in the human genome. And how do they do that? They set up what we call DTC genomic companies, direct-to-consumer genetic companies. Companies like 23andMe was one of the granddaddies or the grandmothers of it all. Navigenics, Decode Genetics, which I think was based out in Iceland. Out of these three big companies that really started to pave the way, 23andMe is the only one that's left. The other two have been swallowed up by other companies. But ultimately, the goal of these companies was to gather genetic information. And again, 23andMe is very forthright in saying, we are interested in collecting genetic information. And they've done some good. In fact, so initially 23andMe, this is a Wired article from when the beginning of 23andMe, and it's hard to see, but maybe we can blow it up. So what 23andMe promised was looking at various disease traits, whether or not you're gonna have back pain later in life, or or maybe you'll have high cholesterol, or maybe you'll have freckles and stuff like that. And so this was what they promised was, you give us your genetic information, and with this genetic information, we will tell you everything you want to know about your future and maybe a little bit about your past. And unfortunately, this didn't work for a whole host of reasons, but one of the things that did work, and perhaps unparalleled in the world of consumer goods, is what these companies did. And that is, so when they started sequencing human genomes, it cost $3 billion to sequence a human genome. By 2000, it was still $100 million to sequence a single human genome. Today, it's a couple $100. There is no other consumer product in the history of humanity that had seen such a precipitous decline in the cost of the product. Imagine a house. Toronto, I think housing prices are probably out of whack. But imagine, one day your house costs $3 million, and then 20 years later that house has a value, costs $100, right? That's not even a fraction of what this is, right? This is $100 million down to a couple $100. It's incredible what it did. And 23andMe, again, was sort of this, this was the wonder couple. This was Anne Wojcicki and Sergey Brin. This power couple from Silicon Valley had come together, and they were going to change the world. And in fact, all the hoity-toity of the world got together, and they had these parties called spit parties, where you would go, instead of a Tupperware party, you'd go and you would spit into cups at these parties, and they would collect your DNA, and they would ship it off to companies like 23andMe, and for a couple $100, you'd get all this information. This was in sort of the section of the New York Times that talks about all these fancy parties. Whatever it is, and again, when in doubt, spit it out. These are all these parties. Now, what they did was incredible, because not only did they bring down the cost of sequencing human genomes, but ultimately they got millions of people to actually have their genome sequenced. And this is, of course, very valuable. because this information is very important for personalized medicine, it's very important for finding new drugs, it's very important for a whole host of issues and ideas and moving science forward in general. Now, actually, my students actually were working on one project because unfortunately, of these 26 million people, most of them were middle to upper class white people. And this demographic wasn't well represented. Other demographics, other minorities were not well represented in this data set. And so there is a group that I was working with at Yale recently that was actually looking to go into the prison system in the US, because there are demographics that are overrepresented in the prison system in the US that are underrepresented in these 26 million, and try and find a way to ethically, morally get information from them and have incentivized people in prison to give genetic information. That way we can have personalized medicine for all, we can have targeted drugs for all, and I don't know where that's going right now, but this is an effort that's going on which is what this program called All of Us, which was renamed by Trump. I think All of Us is a silly name, sorry to the camera. It's a silly name, but Trump renamed it to that, and that's what we're playing with today. But it's this idea that we can sequence a large portion of people, and with all that information create a lot of data. And a lot of scientific advancement. Now, 23andMe again was at the forefront of this world. And even 2 years ago or 3 years ago, we have Google searches. We see 23andMe was still riding high. Here's 115 million people, 115 million novel searches for 23andMe. Ancestry.com is far away, and MyHeritage even further away. These are sort of the three big companies right now. Now, along the way, 23andMe took a number of spills, a number of falls. I don't know what happened. I'll tell the camera this. I really have no clue what happened, but somewhere along the way, someone at 23andMe dropped the ball, got the FDA incredibly upset at them, and essentially the FDA said, you know what? If you're not going to play with us, then we aren't going to let you do anything practical with the knowledge that you're collecting. You cannot give people medical advice, medical information based on the genomic sequences. You can tell them about their ancestry, you can tell them what part of the world they're from, and that sort of stuff, but that's it. As a result of all these warning letters that went back and forth, I don't know how 23andMe dropped the ball so badly. The FDA got really upset at them for at least a decade, told them they couldn't do anything, and then only in 2017 the FDA started to let them slowly build back up this sort of thing. Now, in the meantime, 23andMe has a horrible business plan. What is their business plan? It's been essentially, well, there's two parts to it. Number one, you pay us $100 and we will sequence your genome. And number two, if you pay us a subscription fee, then we will give you more information as it comes along. Now, of course, that got killed by the FDA that essentially said, you can't do that. So they were essentially in this sort of one and done business plan, which is a horrible business plan for a very expensive sort of, why is everyone calling me? A very expensive sort of process. And so 23andMe had to look for an alternative to this, business plan, and what they found was partners in Big Pharma. So we have 23andMe working with GSK, essentially selling all their genetic information for $300 million, which sounds great. But no one else took the bait, and GSK was the only company that I think bought this information, and I don't think anything great came of it. By the way, anyone who actually had their data sequenced by 23andMe got anything out of this $300 million. 23andMe pocketed all the money, and so the goal was to leverage genetic insights for development of novel medicines. Didn't work out so well for 23andMe. They had one buyer, and that was it. So their business-wise, they haven't been doing well. And then along comes the real world, and they get hacked, right? Famously, there's only two kinds of companies in the world: those that have been hacked, and those that don't know that they've already been hacked. Mm-hmm. And 23andMe is one of those companies. They were hacked. They settled for $30 million. It particularly targeted Jewish and Chinese customers, according to this lawsuit. They promised to pay up to $10,000 per data breach to the victims. And as a result, this is a second hit. So their business model has been eviscerated. They now owe money for this litigation. And as a result, and a whole bunch of other things, their stock market plummets to the extent that it's lost 99% of its value. 23andMe used to be a $6 billion company, and now it's worth pennies. And of course, the board resigned en masse, and supposedly in the history of modern finance, that has never happened for a NASDAQ-listed company. So things are really bad for 23andMe. So who cares? Why should you care that things are, unless you're invested in 23andMe, why should you care that things are really bad for 23andMe? Well, the problem is that 23andMe has somewhere on the order of 23 million people's genetic information sequenced. And people want that data, and not necessarily good people, and not necessarily bad people, not necessarily people with malicious ideas in mind, but still people want access to this data. And 23andMe is now in a position where they've got to pay $30 million for a lawsuit. They are essentially worthless. The founder cannot buy back the company, and so what can they do? They can sell the data to the highest bidder. And surprisingly, there's very little that the regulatory system can do to stop them. So we are now in a system with a very centralized genomic data system, a lot of data, and there's concerns not only of people accessing this, but even governments and stuff like that. You don't have to look far to think about the Golden State Killer, who was, some guy who ravaged the California state, in the 70s and 80s. He raped, he murdered, he burgled, and he was found because of a company like 23andMe. There are a couple of private sleuths that were looking at this publicly available genetic information and accessed information about that. Now that sounds great, but not so great. So there's another case, went up to the United States Supreme Court, where it was a Fourth Amendment case. For some reason I'm blanking on the name, and I should have listed it here, but I didn't. Where King v. Maryland. So Alonzo King was arrested and booked for a relatively minor, I think a bar fight or something like that. And surprisingly enough, when they took his DNA for just being arrested, they found out that he was somehow tied to a cold case rape that happened a number of years prior. And King, essentially, there's, again, if you watch CSI, I don't know if this concept exists in Canada, but there's this concept of fruit of the poisonous tree, where if you get, does it exist here? Yeah? Where, again, so if you get access without a warrant to information that is incriminating, if you don't have a warrant, then that evidence gets thrown out in court. And so this is what he was arguing the whole time, and the Supreme Court essentially allowed that evidence to be included. They said that sequencing someone that gets arrested is standard procedures like a fingerprint and a mugshot. Now, interestingly enough, we had a number of minority opinions here, and the most interesting minority opinion was that of Justice Scalia, who's now dead. But Justice Scalia, channeling Jeremy Bentham. Anyone a Bentham fan? No? Anyone been to University College London? I think it's University. Bentham, right, the philosopher, he lives on. His body's essentially been mummified. He lives in a little phone booth in, I think, University College London, and they roll out his body. It's in his will that he has to be rolled out and included in every sort of major board meeting. His head has fallen off, and they put on some gruesome sort of wax head, but he still is there. And one of the ideas that Jeremy Bentham came up with was this, what he called the panopticon. A panopticon is a jail, right, essentially where the jailers are in the middle and the prisoners are all around. And what a panopticon is this idea that the prisoners never know that they're being watched. And so they're in constant fear that they are the ones that the jailers are watching, and they don't know. The jailers could be sleeping, they could be playing on their phones. No one knows who's watching the prisoners. But this is this idea that Jeremy Bentham came up with, this supermax prison that was his idea. And Scalia said that what we are doing by giving the government access to genetic information is creating what he called a genetic panopticon. This idea that everyone will essentially feel that they are being watched by the government because their genetic information is being held by the government for a whole host of reasons. And using that information, the government can, can arrest their third cousin for a crime or find out that they were somehow involved in a crime. So that's one thing that would happen if 23andMe, let's say, sold their information to the US government. Now, the US government is also somewhat concerned about this sort of information getting out. And so in the waning days of the Biden administration, Biden had an executive order that turned into one of these laws that got passed under the radar in one of these sort of big sort of appropriation bills called PADFA, which is the Protect American Data Something Act. And PADFA is actually primarily only, it limits the ability of people to give their data or to sell their data or for companies to sell very personal data to only a handful of countries, which I think are now called CRINC. Is that what they're calling them now? China, Russia, Iran, North Korea, and somehow Cuba and Venezuela were also in this. No one's heard the CRINC term? I saw it recently in the Wall Street Journal or something. Okay, CRINC. How are we doing for time?
We're good.
How much more time?
You still have half hour.
Great. Okay. So PADFA is this idea that there is data that the government considers to be too valuable that we can't allow it to be sent out to these countries. And I'll make this available if anyone wants it. But there's ideas of national security risk. There's concepts of not sending out what we call omic data. That's metabolome, proteome, genome, all this sort of stuff. And there are restrictions. They've done a lot of work to make sure that you have to have contractual. If you want to sell genetic information to a third party outside the country, you have to have these sort of contractual restrictions that you can't provide this data to one of the CRINC countries. You have to have enforcement mechanisms. There are anti-evasion provisions to make sure that you're not secretly sending it to CRINC. And of course, there are huge civil penalties, really, really big civil penalties. $368,000 per violation, $1 million fine, 20 years in federal prison. This is not something the government is taking lightly. And again, they snuck this in under the radar. What are they afraid of? So what? So China, Russia, Iran, North Korea, Venezuela, Cuba have access to our genetic information. What are they afraid of? So I think one of the things they're afraid of is this. This is Putin's giant table. Anyone seen this recently? Right? Whenever he has these meetings, so we've got Putin over here, can't miss him. I think we've got Bolton over here, and they're sitting at this giant table like normal people would. They don't always sit at this giant table like normal people would. Before Putin attacked Ukraine the second time around, there was a lot of sort of diplomacy trying to make sure that he didn't go in and attack Ukraine. And so we had a lot of sort of Europeans go over, heads of state, to try and prevent Putin from doing that. And so, here's a same table, different picture. Right? Anyone remember that Batman movie with Michael Keaton, where they're sitting in Wayne Manor across that giant table, to pass the salt, right? Why are they sitting at this comically large table at opposite ends of the table? Is it because they don't like Putin? Well, they don't, but what's going on here? Anyone know? No? I'll give you a hint. This picture was taken around 2020. And what happened was that so Macron here, essentially went over and tried to convince Putin that maybe you shouldn't attack Ukraine. And Putin says, sure, come, we'll talk about it. I just need you to take a COVID test before you come over to Russia. And Macron said, are you nuts? There's no way I'm giving you access to my genetic information through a COVID test, and you're going to use that information somehow against me. And so Putin said, fine, you're not going to do the COVID test, don't come near me. And so they're sitting across on this comically large table. The German chancellor, I think, also did the exact same thing. Why? Because they refused to give Putin their data through COVID tests. And I wrote a paper, I think, essentially saying that it never happened, fortunately, but I thought that we were on the cusp of governments collecting genetic information at airports because we were doing COVID tests at airports. We had all this infrastructure, all this testing infrastructure. Maybe they are doing it, but why not use that to do genetic testing at airports to look for other things that perhaps we find undesirable in the human genome and prevent those people from coming into the country. Now, fortunately, that didn't happen. Nevertheless, there is this fear. This is also something from the US Army. This came out in 2020 as well, where essentially service members in the US Army were told don't do direct-to-consumer genetic testing because we are concerned about what this information will be used for, and we are concerned perhaps that this will be used to build biological weapons against our troops. Okay, so this is a concern. And so we have the government, at least the US government, trying to limit the sharing of genetic information across international lines. What about us? What can we do to protect our own personal information that perhaps we've given to 23andMe or one of the other sort of shady fly-by-night sort of direct-to-consumer genetic companies? And, you know, one of the questions we have to ask ourselves when we're thinking about this is, do we own our genetic information? Do we have the ability to tell people what they can and can't do with our genetic information? Because maybe we don't own it. And why do I say maybe we don't own it? Henrietta Lacks. Anyone know Henrietta Lacks? Yeah, they made a movie about her. What was Henrietta Lacks? She was a poor woman who lived in Baltimore. She had cervical cancer. The surgeon came in, took a pathological sample, and lo and behold, they found that she had amazing cells. Her cells live on today. They're called HeLa cells. It was an open sort of secret that HeLa, which we tried to anonymize her name, was Henrietta Lacks. And there was a book that came out in the mid-2000s, early 2000s, that essentially made this very, you know, not secret public. And I think Oprah made a movie about it. And so the world found out that this woman had given her cells. She had kind of consented. We didn't have consent yet, but she had kind of consented to have her cells taken by the doctor. And what happened? Eventually, the family of Henrietta Lacks demanded, and has actually sued on a number of occasions, profits that have resulted from literally tens of thousands of papers and perhaps some drugs associated with these the many sort of miraculous sort of things that we found using her cells. Have they gotten anything? Nothing. I mean, the most they've gotten is the WHO made them goodwill ambassadors, right? It was like some sort of prize. That's all they've gotten. They haven't gotten any money. Maybe they've had one settlement, undisclosed how much it is, but effectively everyone has shut them down, essentially saying, no, you don't have access to your DNA, you don't have access to your cells once you've given them up. There's a long line of case law to this effect. I don't know what the Canada law is. I'm trained in the US. But we have Moore versus the University of California in 1990. This is a famous case where we have a guy, again, it was a squamous carcinoma, I think, or hairy cell leukemia. And again, the pathologist takes a sample and is astounded by the cell line and patents it. And Moore gets none of this. And so Moore sues. And the courts essentially say, you've got no rights to this. Yes, it came from your body, but once you give it out, you have no ownership rights over effectively what comes out of your body. Later on, we've got this case out of the 8th Circuit in 2007. This is Dr. Catalona. Dr. Catalona had a clinic for prostate cancer, and he collected samples from up to, I think, 6,000 or 10,000 patients, and he created a giant, very, very useful database where he had all these samples. And then Dr. Catalona got a better job than Washington University because no one wants to live in St. Louis. I'm sorry to the camera again. So, there's some bad parts of St. Louis. And he was moving out of St. Louis and moving to a different university, and he asked I think up to 6,000 of the patients who had given their cells for the database, write to the university and tell them that you allow me to take your samples to my new place. And they did. They loved the doctor, and they willingly wrote these letters, and the university said, I'm sorry, this is a very valuable data set, we are not letting you take it out of the university. And they sued. It went up to the appellate court, and the university won. Again, along the same lines of Moore, that you do not have rights. Once you grant it over, you cannot write to the university and say, we demand that these donations that we gave of our cell lines and our DNA travel with the doctor? The court said no. Perhaps the worst case is a case from a little earlier in 2003, which is Greenberg versus Miami Children's Hospital. Again, there's a patent involved here. Oftentimes there are these rare diseases where drug companies have no incentive to get involved, and so families will get together and they will find doctors that are interested in solving the disease. Canavan's disease is a horrible disease, and they were looking for a doctor that would help them create a test for it. The doctor got all their genetic information and got a patent, and you can notice on the patent is the University of Children's Hospital in Miami, but none of the parents. They got nothing out of it. It was signed to the hospital. They got no money from it. And again, because of Moore, once you donate your genetic and biological information, you have no right to it. In fact, they made a sad comic about it, right? I've isolated the Canavan gene from tissue donated by afflicted people. Great, I'll file a patent application and put together a business plan to screw the terminally ill, right? And the court said that's fine, you can do that. And perhaps the most recent case is the Havasupai tribe out in Arizona. Arizona State University had a relationship with the Havasupai tribe. You give us your genetic information, and we will do some interesting sort of analyses and see correlations that we can find for diseases that are of interest to you. And the Havasupai tribe said, that's fine, just don't do research on diseases that will, besmirch the tribe. And so ASU said fine, and of course ASU didn't. They did all this sort of other stuff on it. They were only supposed to do for diabetes research, and they did it for schizophrenia, alcoholism, and other disorders, and the Havasupai tribe was very upset. They sued for $50 million, and they settled for $700,000. Why, if you sue for $50 million, are you going to settle for $700,000? Because you have no case. Because the Moore line, it doesn't exist. You have no opportunity to do this. I should know, in full disclosure, when I was an early genetics researcher, I was doing this as well. I was getting genetic information from various tribes in Africa and in New Zealand and in Papua New Guinea and all this sorts of in South America, where we were collecting all this data to look for correlations between schizophrenia. Schizophrenia is a horrible disease, exists in 1% of the population throughout the entire world. And so we're looking at very sort of isolated tribes and trying to find out whether or not dopamine receptors were associated with schizophrenia, which they are. So that is this line of case law that essentially says you have no rights. Along the same time, we also have a similar line of case law that essentially says that you cannot patent these sorts of genetic information. You can't patent facts, right? So we have famously, initially we started out very sort of pro-patenting this sort of stuff and giving ownership rights to it. So we have an early 101 case essentially deciding that anything under the sun made by man, even a living organism, can be patented. But very soon after that, we've got a case that looks at databases and facts, and essentially the court says that's fine, but you can't patent facts, including genetic information. Like I said earlier, I was really interested in this, and at the same time that the Americans were shutting down the ownership of facts, the Europeans were opening it up. They had the European Database Directive from 1996. The Americans were thinking about this in the early turn of the century. I was very much interested in this. And effectively, the Europeans actually created a database protection regime that essentially allowed you to protect certain facts. To some degree, the Digital Millennium Copyright Act lets you protect some certain facts in certain instances. But that's been weakened, and the European effort has also been weakened. But there was initially an effort to allow you to protect facts, but that has gone by the wayside. We have a whole number of case law. This was the case with Mayo, where essentially anything that was associated with biological processes could not be patented. And then we have Myriad Genetics, which is another case with the BRCA1 and BRCA2 genes that essentially said, also this stuff you can't patent. So initially we had an effort to grant ownership rights to biologics and to data, and then very quickly after that we turned very far away from that, and perhaps nothing exhibits this more so than GDPR. We're all familiar with GDPR, the privacy laws of the European Union, and why did they create this system? because they couldn't grant ownership to facts and this sort of information, even genetic information. The Europeans decided we are not going to go the way of granting you ownership rights that allow you to protect it. Rather, we were going to make a regulatory regime that surrounds your personal information with a whole bunch of restrictions, and instead of granting you ownership to this information, we will regulate that information, but will not grant you ownership. Right? So GDPR gave you the right to be informed, the right to access, the right to rectification, the right to erasure, all these sorts of rights, but not ownership. These rights were in lieu of ownership. And so why do we not want to grant rights to factual information and to genetic information and the like? Well, because facts are very different than other sorts of property, right? Facts are non-rivalness, non-exclusive, inexhaustible. They're very different than other sorts of pieces of information. And if we grant ownership rights to them, we lose a lot of sort of what makes facts and genetic information, all these sorts of things, very useful and powerful and great to promote science and innovation. So one of the ideas I think that has come out of the GDPR is that, again, Google doesn't own your data, and you don't own your data, but Google is like, imagine you go out and you buy a car, from Danny DeVito and Matilda, right? Great movie. And Danny DeVito tells you, sure, here's your car, enjoy it. However, I want to see you every Tuesday for an oil change. I want to see you every Wednesday to wash the car, and every Thursday you have to drive it around the block 3 times and honk the horns twice. Who owns the car? You or Danny DeVito? Right? If I own the car, Danny DeVito can't demand me do certain things with my car, because it's my car. How can he make these demands on me? You could argue the same sort of thing is GDPR. Google doesn't own your data. Google is, and effectively they must be custodians over data, right? They don't have ownership rights, but they have custodial rights. They can do a lot of things with it, but they can't own it. But do you own it? Do you have ownership rights over your data? And particularly, again, your genetic data. So I think, so yes or no? Should we or should we not? So why should you have ownership? Well, there's a whole bunch of reasons why you should. It's yours. It's your genome. Why shouldn't you have ownership over it? There is a strong connection between your genome and your medical history and there's a world called behavioral genetics, so even your personality and all these sorts of things. There's a strong connection between you and your genome. So maybe you should have ownership over it. But there's a problem, and that is your genome is not your own. Why not? Your genome is huge. It consists of approximately 6 billion letters. Each letter corresponds to a molecule. If you wrote out your personal genome in a book, it would be 201,000 page books or 1,200 page books. Nevertheless, it's a huge amount of information, of which we're only slowly trying to figure out what most of it means. Only 2% of your genome actually codes for your genes. The rest of it is junk and other stuff. But of your genome, most of it isn't yours. Why is most of it not yours? Well, first of all, we share a bunch of our genome with higher ordered apes. 50% of our genome is actually shared with bananas. So we share a lot of our genome with other people, but most of the actual useful parts of our genome, our genes, are actually shared with our families. Right? Your siblings share 50% of your genome. Your parents share 50% of your genome. Your grandparents share a smaller percentage of that. Your cousins, your aunts, your uncles, everyone shares part of your genome. So if I go to 23andMe, for example, and I say, sequence my genome, they're not only sequencing my genome, they're sequencing my family's genome, my siblings, my cousins, my uncles, my aunts, my parents, my grandparents, all their genetic information is being sequenced as well. And so to say that I have ownership over that is very complicated, because it's not only me, it's a whole bunch of people. So there's a whole bunch of reasons why you should not have ownership. Number one, it's shared, it's a public good, it belongs to humanity, it's not just me. It impinges on my relatives' ownership of their genome, because let's say I want to share my genome with the world, like Watson, right? Everyone's familiar with Watson from Watson and Crick, the discoverer of the human genome. He, when they first sequenced the human genome, he was granted a present. This was before people decided they really didn't like him, and he had to sell this Nobel Prize because he couldn't get a job. He eventually got it back. Some Russian oligarch bought it and then gave it back to him. But James Watson was gifted his genome in the early 2000s. And what did he say? I'm giving this to society, to humanity. Everyone can have access to my genome, and they can do all the research they want except for one gene, the ApoE4 gene, which has to do with early onset Alzheimer's, and also whether or not you can survive from a concussion. But he gave it away freely. But what about all his family members that were also in that genome? He didn't ask them, they didn't consent. Does he have ownership right that he can do that? Unclear. And perhaps I think that what we saw in the GDPR, this concept of ownership versus custody, we can also argue the same sort of thing for genetic information. Ownership versus custody, you own some aspects of your genome, but the rest of it is only custodial. And I think one of the ways that we can see this, very interestingly enough, is in the case of Dr. He from China. Anyone remember? A couple years ago, he CRISPR'd, I guess that's the verb now, he CRISPR'd two young twin girls, and he took out he deleted the CCR5 receptor gene from their cells. Why did he delete that? Interesting story. As HIV was ravaging Africa, they found out that there were certain prostitutes that were not getting AIDS. Why not? They determined that they were lacking the CCR5 receptor gene, receptor protein in their cells, and they found out that the HIV virus cannot get into the cells without this receptor, and so these people were essentially immune. And so what Dr. He said was, why don't we make these girls immune as well? Of course, there's a whole other ways to make you immune or to prevent you from getting HIV, but he decided, why don't we mess around with their genome? And people were very upset, and he was disappeared from China, by China for a number of years. He slowly made his way back. No one would publish his research. Why are we so upset about this? What is so bad about manipulating the genome? We do it all the time. There's a drug for hemophiliacs. It costs $2 million a pop. You only need it once. It manipulates your genome to make you no longer a hemophiliac. Why do we not have a problem with that, but we have a problem with Dr. He? What's the difference? Well, I think the difference is that what he did was he manipulated what we call the germline genome, the genome that belongs to all of us, the genome that we pass on to our children and to our grandchildren. When you manipulate the hemophiliac gene, it's only what we call somatic cell gene. It's only the gene that is relevant for you, and you don't pass that manipulation on. And so again, this idea of custody versus ownership sort of leaks into the scientific world. Okay, so let's move on quickly. There are no laws in the US that grant you ownership of your genome. There are laws, again, like the GDPR, that grant you protection in the sort of the penumbra of your genome, of ownership. You know, you've got HIPAA, you've got GINA, you've got the common rule, all these sorts of things in the bioethics space. There are a couple state laws that do it, grant you actual ownership in your genome, but for the most part, like Europe, you're only granted rights to control, but not to own your genome. Canada also gives you some sort of protection rights. I'm going to skip through this. So let's think about practically what's going to happen with your data with 23andMe. If you don't own it, and maybe they don't own it, then how do we protect it? All this data is out there. How do we create a system that deals with ownership of this very personal, very valuable, very sort of dangerous sort of data? Now, the direct-to-consumer genetics companies have already solved this. They've essentially created contracts. Regardless as to whether or not you actually have ownership rights, they created contracts. And these contracts are like sort of these frameworks that essentially disclose and describe how we're going to allow you to have access to your genetic information, what we can do with it, what you can do with it. And it's all, essentially, they're not bound by any sort of the regulatory oversight. And this is what they're doing. These companies are called recreational genomic companies. They're not even in the clinical space. And so they're very loosey-goosey in terms of what they can and can't do. And so contracts are the way to go. But they don't solve the ownership issue. How much time left?
You can take another 10.
Okay.
Like 1:30.
So anyone who's done property law knows there's a whole bunch of ownership sort of theories, right? You've got the res nullius theory, that essentially it's no one's property and whoever grabs it gets it. You've got the Lockean labor theory, which is called sweat of the brow. Whoever put in the effort gets it. That was sort of thrown out, at least in the US, by the CAIS case that I mentioned earlier. You've got contractual ownership, which is essentially what direct-to-consumer companies are doing. You've got personality-based ownership rights, that it's mine, so it should be mine. because it's me. You even have a collaborative ownership sort of system where we share it. So you sequenced it, but it's mine, so we have sort of shared ownership. And perhaps the best thing that we could set up is, again, maybe some sort of sui generis sort of system where we actually sit down and we figure out how we can have ownership rights over this very important piece of data that seemingly is unownable. Now, I think we're getting there. And I think we're getting there in Europe faster than we're getting there anywhere else. So like I said earlier, Europe has been on this sort of kick that we can't grant you ownership over your data, but we can grant you protection over data. And I think they switched gears under the table and no one has noticed. And that is in the European Data Act. How many of you are familiar with the European Data Act? Yeah? A little bit, right? No one knows about it. Why does no one know about the European Data Act? Been under the table. It's passed, right? It's in effect as of January 2024. It's been around for at least a year already. But no one talks about it. People talk about the AI Act, people talk about GDPR. No one talks about the Data Act. Why not? Because no one wants to make any noise about it. Why? Again, because, and interestingly enough, in one of the first versions of the Act, they didn't even grant, so what is the Data Act? I'll say. The Data Act essentially forces companies in the European Union to share data with peer companies. It essentially says, it's very much focused on IoT, so Internet of Things devices. Essentially, if I am a company and I am creating data, then another company can come along, knock on my door and say, please give me the data, and I have an obligation to do so, provided that we all are nice to each other, we have to share the data. Initially, the law didn't even include any sort of trade secret rights or anything like that. It essentially said, you've got to share your data. Now this seems to be the pinnacle of no data ownership. You don't own your data, no one owns your data, no one owns information, we have to share it to make a bigger and better Europe. But what they did do, some people who were involved in this sort of hinted to me that this is what they did, was they've essentially created an ownership right in data. And that's why you would think that companies like Google and Meta and all these major giant data companies would be up in arms and would make a lot of noise saying we can't have this, we must take this down, we're not allowed to pass this, but they haven't. Why haven't they made a lot of noise? I think personally it's because they see through what the EU is doing, and the EU in the Data Act essentially in two particular recitals, 46 and 15, they've created a functional model of data ownership in the Data Act. Now, I don't know if they intended to do it. I think the data companies are trying very hard not to rock the boat so that they don't turn around and say, no, there is no data ownership rights, but I think what the EU Data Act essentially is granting enough of a bundle of rights to essentially grant ownership in data. And this is a massive change in this world of data ownership. And if we can transfer this to the world of genetic information, and we can grant ownership rights on genetic information, we can prevent 23andMe and other companies like it that have essentially just collapsed from sharing that data with people that we don't want to be sharing with. So summing it all up, I've sort of gone on a whole tangent all around the world. DNA is a unique type of data. It requires distinct regulations, very valuable information, could change the world, and it uniquely identifies you to the degree that you cannot, it's exceedingly hard to anonymize your genetic information. And it's in a number of databases all over the world. You've got Interpol has a genetic database, Canada has a genetic database, the US has genetic databases, and there's public databases and private databases. All this data exists out there. And there currently isn't any way that we, as the sources of that data, have any rights to control it and to do anything with it. And I think we need to create policies and regulations that regulate the entire life cycle. Even the collection, the storage of it, who can store it, who can share, can 23andMe sell it? All these things aren't regulated. I mentioned earlier that there's a PADFA law that again was also passed under the radar as a part of a giant appropriations act. You can't even find any news stories on it. You can only find you find some law firms that are sort of talking about it, but there isn't any real news stories on it for some reason. But none of them protect data by granting us any ownership. So what can we do? I think what we need is, despite all the problems with 23andMe, there's a lot of value there. They incentivize a lot of innovation. they discovered a lot of information, they created a lot of information, and I think what we need are these sort of public-private sort of partnerships where we have the strong push for innovation, but we also have the strong push to protect the information of the citizens of the various countries. We need to think about how to protect databases, how to enhance data protection, particularly in the area of genetic data. And this is coming from myself, who, 25 years ago, I was writing papers saying, give me everyone's genetic information because I want to do research. And I'm now turned essentially 180 on this, and I really think that it's really not right, because again, it's not only my genetic information, it's my family's genetic information, it's my children's, my siblings, we all share it. And we need to figure out a way to do it better, but not to sort of squelch this innovation and the value that we can do. With this, developing sort of standards, creating safeguards, preventing companies like 23andMe from selling the data if they choose to do it. They haven't so far, to Anne's credit. They have not sort of in any way indicated that they're just going to sell it to the highest bidder. We need to find sustainable business models that will allow them to use our data for a whole bunch of things, but also allow us to profit from the use of our data, because again, that 300 million that came from GSK to 23andMe, none of that trickled down to the people. We need regulations, we need standards, the whole standard sort of thing. Opt-outs, independent oversight, strict penalties and the like, corporate responsibility. I hope I haven't scared you. I think that there is a lot here. There's a lot going on. There's a whole bunch of different areas of law that are all coming together. And there's a whole bunch of business aspects, and at the top is 23andMe, which is falling apart. And so thank you very much.
Wow. Thank you very much.
I think I talked too quickly.
That was just an incredible constellation of so many layers of the law, social issues, data, AI, all coming together and really trying to figure out a path forward. Because these issues we're facing them now. Right. And they implicate all of us in a very intimate way, as you pointed out. So thank you for that.
Thank you.
So some time for questions. Any thoughts on what we should be doing, or did anything surprise you?
Anyone want to sequence their genome now?
Yeah. All hands up on that one.
No, there's always these cases in the news where like the dad goes out, or the mother goes out and buys a whole family stocking stuffers for Christmas, and they all get like a 23andMe gift certificate, and they all go out and they sequence their genomes, and then suddenly, that wasn't the dad.
Yeah.
There's always these stories.
Yeah. So any thoughts? I love this actually, because it dovetails so nicely with earlier work that I also did on data and even pre-AI, right? And now with all the talk on AI, as you point out, no one really talks about like the data part.
Right. Well, there's a lot of litigation in this space.
Yes.
Over controlling this data. Yeah.
So then, like your thoughts just for Canada. Right now we had AIDA, which was tabled and died on the order paper. So when we resurrect some AI legislation, should we bring in a data act with it, or try and morph it into AI legislation, or do something sui generis standalone, but then have at least the two pieces of legislation talk to one another?
Right.
So what do you think? Because right now AIDA was just focusing on the privacy and the cyber, not so much the ownership implications at all about the data.
Right.
So just wondering your thoughts.
When I think about regulating sort of these emerging technologies, I don't know if it's true or not, but it's apocryphal, what California did with autonomous cars. So when California created their first set of regulations for autonomous cars, they called up Google. They said, hey, and again, I'm not sure if this is true or not, but this is what I've heard many times. They called up Google and said, hey, tell us about your autonomous car that you're testing. We want to set up a bunch of regulations for testing your autonomous cars. Tell us what your car is, and we'll set regulations that fit your car. And then Google 2.0 came out. They had a new car, and it was totally different than the initial car. None of the regulations that it set up to fit the initial car fit the second car. All these obligations, steering wheel, no steering wheel, sort of silly things. But I think it's very dangerous to look at technology today, because prior to ChatGPT, no one was talking about AI. AI was in a winter again, and everyone thought, well, nothing's going to happen except for Aviv. But it was we were in a winter, no one was seeing a lot of progress, and suddenly ChatGPT came out, and law firms of all places said, well, we're going to. I remember I remember it was a huge day in my law firm. It was like, wow, we're getting new technology for our law firm. This was in 2008, 2008, I'm gonna say, maybe 2009. Silicon Valley, big tech law firm. And what was this new technology that we were getting? We were migrating from Microsoft Office 2000 to Microsoft Office 2002. And this was this huge technological advancement in our law firm, because law firms they're dinosaurs and they're technophobes. And yet they've, Cleary Gottlieb just the other day bought some AI law company, just yesterday, I think, right? And so, Cleary Gottlieb is like a white shoe New York firm that would never do tech, and now, right? And suddenly ChatGPT has sort of changed the whole world. And it wasn't predicted. I mean, maybe the OpenAI guys would have predicted it, but we as a society, the lawmakers, would not have predicted where we've gone. And then to come in today and say, well, we're going to make a new law based on what we know today, without any idea of what's going to happen in 2 years. Are we going to be an AGI, artificial general intelligence? Are we going to be some sort of super intelligence? Are we going to meet the singularity that Kurzweil talks about? Like, where are we going to be? I think it's sort of short-sighted. I think we need to make very sort of targeted, sunsetted regulations and legislation. I think that's the best way to go, because I think we'll be kicking ourselves by by seeing where AI will go next.
Okay.
That's just my
Good
take
advice.
on it.
Yeah.
Any other thoughts or questions to add to this? What about in terms of the who or the what?
Mm-hmm.
So there's a lot of discussion on which key players should be involved, to what extent the government should have a piece of this, or it sort of sounds like it should be a hybrid approach
I think,
from
yeah.
what you propose.
I think governments are slow to react, but tech companies are greedy,
Yeah.
and they're hard to predict where they're going to go. Like Google is no longer do no evil, right?
Yeah.
And so people are very upset at all the tech bros that suddenly went for Trump, and Peter Thiel and Elon Musk. So everyone was buying Teslas, and now everyone's complaining about Teslas. So companies are fickle and governments are difficult, and I don't know what's the best sort of interaction, but something in the middle where
Yeah.
we take the best of both and try and throw out the worst of both.
Okay. Well, that's very Canadian. So
Okay.
I think we'll end on that note and with a big round of applause. So just a small token of our appreciation. Very made in Canada for you, made at York University for you.
Canadian, right?
Yes, exactly. So we're very grateful. So it's really a time to say thank you. Thank you for reaching out. Please reach out again. We want to keep working together and welcoming you back and hearing the succession of this story, which will no doubt continue. Thanks for all of you for attending. Look forward to welcoming you back at our events. So look on our socials, on the websites. There are more events in store from both CAIS and Connected Minds. Connected Minds is a big conference coming up in October, so mark your calendars for that. And last, a big thanks to Sandra for all the behind the scenes in putting this together. So thank you, Sandra. And Caitlin, of course, always a rock behind all that is Connected Minds and some, and Joe is here. So thank you, each of you, for all of your support, and look forward to working together and really making the world a better place. And it all starts here, right? So it's all about education, learning, and learning together and from each other. So thank you with that.